Be seated. We are here today for 3 cases. The first case, State versus Amadeus McLean, is hereby submitted without oral argument. The first oral argument today is County Bank versus Shalla, and it looks like the parties are ready. Mr. Riley, you may begin.
If it please the Honorable Justices of the Iowa Supreme Court, I am Peter Riley, and I appear on behalf of my clients, Clint and Michelle Shalla. My clients, the Shallas, were denied the right to present to a jury their claims for negligence and fraud based upon a broad but erroneous construction of the Iowa Credit Agreement Statute of Frauds found in Iowa Code Section 535-17. I'd like to just briefly outline what I think are the most relevant points of evidence before I talk about why the statutory construction was erroneous. My clients, or Mr. Shalla, had entered into an agreement to buy a farm that had been redeemed from a foreclosure by the Koch family. Knowing and hearing that Mr. Gert at People's Bank was making loans, he talked to him, and there is evidence that shows that an agreement was made for Mr. Gert to assist Mr. Shalla in redeeming the option with the agreement, under the agreement with Koch's. The evidence from Mr. Shalla shows he talked to them in early 2015. Mr. Gert claims either it was in August or October. Those are significant because the option deadline was August 15 of 2015, and the option was to close by the 15th. And then Mr. Gert advised Mr. Shalla that the Cooks would not abide by the option agreement, further dissuaded him from seeking legal counsel. Later, loans were made, defalcations were made, but the basic issues that are affected by the statute are the claims for negligence and fraud. It's been well recognized in Iowa, most recently by St. Malachy's versus Ingram, that when you undertake to perform services that may be something that you're not qualified legally to do, nonetheless you assume the responsibilities of that profession. And Mr. Gert undertook to do that for my clients.
My understanding of the summary judgment record, right? I thought that the option agreement, I want to make sure I get this right, was not transmitted to Gert until after the expiration of the deadline.
Well, Mr. Gert says that, but Mr. Shalla basically says he advised and provided it before the exercise date. And the court's
record.
I'd have to go look at it. I'll take a look while the other side is arguing, but I know that Mr. Shalla advised Mr. Gert of the fact of the option starting in early 2015. And we know Mr.
Shalla said in his deposition that he wasn't even aware that there was a deadline until after it had passed.
That is true, that he had not
deadline before it passed if he didn't even know there was a deadline.
The evidence is that Mr. Shalla was not aware of the deadline, as he had not carefully studied the agreement, but he had provided the information to Mr. Gert. Moreover, it remains significant because the evidence was Mr. Gert told Mr. Shalla, you don't need to talk to a lawyer, our lawyers have looked at it. And any lawyer with an understanding of this field would have said, well, under Steckelberg versus Randolph, you have a claim based on an equitable mortgage, and so while it is on its face an option, a deed with an option back and a right to rent, those under the Steckelberg versus Randolph case can be construed by the court as an equitable mortgage. And if nothing else, Mr. Shalla lost the leverage that a competent lawyer would have provided him in the fall of 2015
Is Mr. Gert's agreement to assist and represent Mr. Shalla in the buyback part of the agreement to also finance it?
No, those were separate agreements. There was never any,
Or what was the basis for the agreement? Was that an actual separate contract? And what was the consideration, I guess, for Mr. Gert then?
first of all, there was no written agreement for the assistance. Mr. Gert agreed to do that for the reason that many people in a business agree to help people beyond what they do. Obviously, he was interested, or at least Mr. Shalla would have felt he was interested at the time in making loans to people, which he ultimately did, although at a different bank. But I think now that we have the entire record of what happened, what Mr. Gert was primarily interested in was loan customers with large loans so that he could have opportunities to steal money, which we know he did based upon his guilty plea to all but one of the counts of I think a 15 or 16 count indictment. So whatever the reason is, Mr. Gert did undertake to provide that assistance, and I don't think there's a...
Be part of the same agreement that he wanted to help him get financing for the property, and then also agreed, in the light most favorable to your client, to assist with negotiating the option.
Discussion between my client and Mr. Gert was that Mr. Gert would assist in the exercise of the option. And we know, in fact, that he did that because he's the one who communicated to Mr. Shalla
On the contract to exercise the option without discussing the financing, the alleged interest in getting the financing?
Those are two separate aspects. I mean, he's agreeing to assist.
We think you're right, and there's a fact issue, and you think there are two separate contracts. Would the evidence relating to any of the financing be even admissible? Is it relevant to this claim?
Well, it would be admissible to the claim because the claim was not, you didn't get me a loan. And why could he claim that? Because, in fact, a loan was procured. The claim was, you agreed to assist me, and you made false statements in connection with assisting me. And so the evidence is clear that while there was discussion about getting a loan, that was not what we claim was breach. Rather, we claim that there was negligent performance. And in fact, I think it's significant, if you take a look at the bill that was initially proposed, if you take a look at the legislative history, you will see that the original bill would have barred claims on credit agreements, but prohibit their admissibility. Okay? So in other words, the original law that the House passed basically would have prohibited any mention of an agreement in connection with a loan. Now that doesn't mean, since the law basically says you can't present evidence of a credit agreement in contract law, that means that it's quite clear that in a tort claim, you can say, well, we also had an agreement that he was going to get a loan, which he in fact did, although at $1.3 million rather than $500,000.
I mean, the statute defines contract, and it's sort of a term of art. It sort of means any, what does it say? A promise or set of promises, the breach of which the law would give a remedy. So, you know, any effort to enforce a promise seems to me is foreclosed by 537.17, right?
For the failure to make a loan. But we're not making a claim for breach of contract. We're making a claim of fraudulent misrepresentation and negligence. And so the fact that
Always turn a breach of contract claim into a negligence or a fraudulent misrepresentation claim. If you have a contract to do something and then you fail to do it, can you say you were negligent in doing it and bring a negligence claim instead of when the issue is whether or not the duty was breached or not?
an artful attorney might try and do that, but on many occasions, the Iowa Supreme Court has made clear that negligence does not always apply, like under the economic loss doctrine, under negligent misrepresentation that is very limited in scope. And so, you know, you can't, you know, sometimes, oh, I mean, if you look at it this way, if one's suing a lawyer for negligence, you're also making a breach of contract claim, but you're not talking about, well, we had an agreement written or implied. You're saying that you were negligent in the performance of your duties.
A duty arise in this case if it doesn't arise under a contract?
Well, the duty arises because he undertook to perform those services. That's what St. Malachy says.
Undertaking was a promise. It was a promise allegedly by Gert to arrange financing so that this option could be exercised. Wasn't that it?
Didn't go part at all. And in fact, a loan was ultimately made by an institution that is wholly separate from the institution that existed that Mr. Gert was working for when he made these promises. I mean, clearly, if the claim is based upon negligent performance or false statements, then whether making a loan was an incidental part of the overall relationship is not relevant.
Depends upon this promise having been made, correct? It's sort of a but-for cause, that there was a promise and some way or another, whether it's by negligence or fraud or whatever, you're trying to enforce it, right?
We're enforcing an agreement to represent, we're seeking to enforce by a tort claim and fraud claims an agreement to assist in the exercise of the option. We are not making any claim for the failure to provide any financing.
It's to subsection 7 of the statute, then have on your claim, which says that other common law principles, which I think would include these claims, are displaced to the extent it would dilute the force and effect of the statute. It seems to me you're just characterizing a breach of contract claim as something else for the whole purpose of evading the force and effect of this statute. I mean, you've called it a breach twice during your argument.
He breached a duty. He breached a tort duty. But you see, if you...
Duty arises as a matter of law. This duty arises as a matter of contract. You're claiming that Gert promised to do something. It's not a free-floating duty that applies to everybody in society.
Gert promised to assist my client in connection with the exercise of the option. There is evidence that in the record that he did that. And the summary judgment that was granted before the trial on that, and which was then relied upon by the trial judge, was simply based on the judge felt constrained to follow the Geiger case that said that 535-17 bars tort claims, and under the terms of the statute, it does not. And
If Mr. Gert had said, as part of the financing, I will help you with the buyback, just assume that's what he said, would that be a term of the loan then that would be subject to the statute of frauds?
any loan agreement would be separate. And in fact,
Asking you to assume that as part of the lending, Mr. Shalla goes to Mr. Gert, I'm looking for a loan, I'm doing this buyback. Mr. Gert says, as part of making that loan, I will assist you. If that was a term that he put into that contract, would it be covered by the statute of frauds? I recognize that that's not, there are facts that would suggest otherwise, or at least that's your position. I'm just asking you to make that assumption.
it would be relevant only if my clients were saying, you know, you promised to help with the exercise of the option, you also promised to get a loan, you didn't get the loan, and they're suing for getting the loan. But we got the loan.
Statute defines credit agreement very broadly to include all the terms of the contract. So any breach of any term of the contract still falls under the statute of frauds. Isn't that correct?
Well, first of all, if you look at the definition of a credit agreement, it says a contract made or acquired by a lender to loan money, finance any transaction, or otherwise extend credit for any purpose. And then it goes on to say it includes all of the terms. But we're not suing for an agreement to get credit, nor...
I mean, the problem, I mean, it wasn't the, I mean, Mr. Shalla didn't have the money to exercise the option, right? He needed a loan.
Need a loan.
within the option deadline. And that was essentially what Gert allegedly promised to do, help arrange, right?
Mr. Gert made a promise to assist in the exercise of the option. He also said that he would, separately said he would provide a loan. And in fact, he did.
So what is the claim then? If your claim is Gert said he would get you a loan, or Shalla a loan, and he did that, what's the claim?
The claim is that what we had to, because of Mr. Gert's negligence in handling the negotiations with the cooks, my clients had to borrow more than twice as much money. That's the claim.
And interrelated with the credit agreement? Your issue isn't that he didn't get a loan. You said he did. The issue is he didn't get your guy a loan relating to this prior financing agreement. That's the issue. Isn't that your damages? That he could have had a different financing agreement if Gert would have been more timely?
Portion of the various agreements or understandings the parties had was he would assist in the exercise of the option. And as a result of his negligence or misrepresentation in connection with that part of the client's the party's relationship, he wound up providing a loan that was more than twice what it would have been had the option been properly done. And if the bank had no problem, the other bank, county bank, had no problem loaning $1.3 million on this farm, the county bank or some other bank would have had no problem lending $500,000 on this farm. So if there's any other questions about the credit agreement statute of frauds, I'd like to just briefly touch on the other.
Come back. The clock is growing. It's kind of a confusing clock. That's okay. Yeah. It needs to have a siren, but it doesn't. Yeah. Yeah. Sorry about that, but you get to come back. Who are we going to have first? Looks like maybe Ms. Gronlund. I'll let the three of you decide how to divide your time.
Thank you. May it please the court, counsel. The Court of Appeals correctly held twice, here in this case and in the Geiger decision, that when you have a credit agreement that's the basis of a claim, 535.17 applies, and that's regardless of if it is in contract or in tort. And the court is correct here that we have a clear promise to loan money. The undisputed record is that Clinton Shalla came into the bank and spoke with banker Christopher Gert, and Christopher Gert told him, "I will help you try to secure financing." There is nothing in the record that they ever discussed this option deadline before the option deadline expired. That is undisputed. Clinton Shalla says, wasn't aware of it, didn't even know about it myself. And it's also undisputed that it was Clinton Shalla's own obligation to exercise this option. And yet from this, the Shallas have brought tort claims against the bank that clearly fall within 535.17. And the court has touched upon the definitions, which are so important here, because there is a very unique, very specific definition of both contract and credit agreement that must be followed by the court. They are bound by the defined terms. And to make that even more clear, if you look at Chapter 535 as a whole, contract appears repeatedly throughout the chapter. And Chapter 535 has a defined term section, and contract doesn't even appear there. Where it appears is specifically in subsection 17.
Isn't it true, though, that sometimes parties will have a contract and yet there can be a tort claim based in fraud, for example, right alongside a problem with the contract?
And what 535.17 says is, if you're going to have a claim in connection with a promise to loan money, it needs to be in writing to be enforceable. And as Justice Oxley had pointed to, credit agreement includes not only this promise to loan money, but it includes all terms of that promise. So when you're dealing with a situation where you have a credit agreement, it has to be in writing to be enforceable. The legislature is making that clear here, that if you don't have a claim in writing, you cannot bring that claim. And the purpose of that, it's not a radical one. It makes sense here because you're dealing with high, complex situations where bankers are loaning people money, and if they don't get the loan or they don't quite get the terms that they want, then an artful lawyer can just turn around and say, well, I'm going to bring a tort instead of bringing a contract action to pursue my remedy.
And that is perhaps a defect in the language, it seems like to me, and possibly. I mean, we're talking about, oh, is it wrapped up in the contract? You have to have the contract as part of the claim. I understand that issue. And maybe there are other grounds that these claims would fail, like this negligence claim seems like, it might have other reasons that it would fail. But as far as the statute goes, I guess what I'm struggling with, sort of like Judge Langholtz, is, well, it says in contract law, which, we read that in the backdrop of how the courts interpret contract law, as opposed to what? As opposed to tort law. And so that's really the problem I'm still struggling with.
Two things. To your first point, People's position is, on this record, this claim fails as a matter of law, even setting aside the 535-17. There's just not a record to support a tort claim. To the second part of your question, the in-contract law phrase, it has to be read in connection with the very specific definitions here, which are incredibly broad. As I was saying before, with the legislature specifically defining these terms to be written so broadly, to be any promise or any set of promises, that goes beyond the traditional sense of contract law.
A little bit what I'm struggling with, because we do have cases, and including our cases, and I think we cited Scalia and Gardner's book for this, that say even when you have a defined term, you don't throw out kind of the common sense meaning of that term. And when you see not enforceable in contract law, well, and then Mr. Riley says, well, I'm not bringing a contract claim. That does kind of, the phrase in contract law kind of, it gives me a little hesitation here. Because this isn't a claim in contract law as we would normally understand that, right?
And I think that where the court can go next is they can look at those subsections 6 and 7 here. The legislature not only defines contract and credit agreement very broadly, they then go on to say this law is to be interpreted and applied purposefully, and it displaces all common law. So
I struggle with 6 too, because it says this section shall be interpreted and applied purposively to ensure that contract actions and defenses on credit agreements are supported by clear and certain written proof. So again, they build in that contract actions. Where do we go with that?
Action is also defined in the definition section, and it's another very broad definition. It's really any proceeding or claim that could be had here. So I think when you read contract and action under those definitions, you still get to the same place. This is a very broadly read statute. Any promise or any term to that promise that could provide a remedy for damages must fall under 535-17 when you read those, when you read Section 6 in connection with those definitions.
Yeah, to be clear, you're saying that in connection with credit agreements, there can just simply never be a fraud claim in tort.
For that, I would say anytime you have a promise to loan money, the promise itself must be in writing, and all terms of that promise must be in writing to be enforceable. If there is a situation where a banker does loan money to the borrower and then would commit theft, if they would steal some of that money, for example.
In this case, there's a conversion claim, right?
The conversion claim is a little bit complicated. So as it relates to People's Bank, there was a line of credit, And the line of credit, the claim was by the Shallas that Mr. Gert misappropriated some of that money and that there was a claim for that. That conversion claim and that fraudulent misrepresentation claim that related to the conversion part of it was not something that was brought, that we made any claim under 535.17. Those claims proceeded to trial.
You have? And why not? What's the difference? That's a tort claim. Why does it not fall under the statute of frauds?
The claim there was, we got a line of credit from the bank, and we claimed that our banker misappropriated some of that money. That would not flow from the promise to lend money in the same way that the option or the discussion about how much the buyback price is going to be and whether they need to seek counsel.
To Justice May's concern about, how broad are you reading contract action?
And I think that, and Justice Oxley, I'll answer your question, then I'm going to be out of time here. But I think that contract action, as I had said, has to be read very broadly under those definitions. I just think whenever you have a promise or a set of promises to loan money and all terms that flow from that, and all the terms here would flow from that, it has to be read to be in writing, to be enforceable under the way that the legislature has written the statute. Thank you.
Thank you. And you are Mr. Wagner? Thank you.
Please, the court and counsel. My name is John Wagner. I'm from Amana, Iowa. I represent County Bank. Pursuant to our division of time, I'm going to be very brief. First of all, the foreclosure judgment in this case is uncontroverted. Even Mr. Clint Shalla acknowledges that there was no error in its computation. In regard to the hiring process, by my count, reading through the transcript, there was 17 different databases that were addressed and cross-referenced, and there were no red flags. Next, Mr. Gert worked for us for a period of approximately 79 days as computed in a footnote by the Court of Appeals. We believe that Mr. Shalla's credibility, the plaintiff's credibility, the defendant's credibility in this case, had real problems. There were about 18 different areas where there were credibility issues, not the least of which they didn't file their federal and state income tax returns for the 2015, 16, 17, 18, 19, 20, and 21 income tax years. There was also substantial impeachment of both Shalla's during the course of the cross-examination. On the other hand, there was uniform support of County Bank and the way they handled the claims, the way they handled the credits by all witnesses on both sides. In regard to the discovery issue, County Bank never agreed to any type of discovery extension. The discovery plan was followed by County Bank. The petition in this case was filed on March 28, 2018. The trial was not until September 13 of 2022. I believe the Court of Appeals indicated that there was 2 full years to conduct discovery, and it wasn't conducted by the Shallas. I believe it was actually a little longer than that. In regard to Gert himself, he testified by deposition at trial that he hid his conduct, any nefarious conduct, from anybody at County Bank, and that nobody was at fault at County Bank. In regard to the action that my client took, Mr. Dan O'Rourke carefully investigated this immediately upon learning of any problem or potential problem. Not only did he investigate it, but they gave the Shallas a $25,000 credit on their mortgage. They also actually paid back into Shalla's account the $2,218 that was used by Gert for the purpose of paying his in-laws' real estate taxes in Benton County. In regard to vicarious liability, we don't believe there is anything about Gert's conduct that was expected, foreseeable, or sanctioned by County Bank. His actions were seriously criminal. They were not incidental to any banking operation. They were a serious departure from the methods of banking, and they were not for the best interest of our bank whatsoever. They were only for the sole interest of Mr. Gert. Finally, in regard to the appellate attorney fees, both the majority and the dissent remanded the case back to district court for the determination of appellate attorney fees, and we would respectfully request the same in this case. Thank you.
Good morning. Thank you, Your Honors. I'm going to jump back to the 537-17 issue. I agree with a lot of what my co-colleague said. It is an extremely broad statute, and there is a specific definition for contract. It's not.
Determine whether or not Mr. Gert's alleged promise to assist with the buyback was part of the credit agreement or not.
Can be resolved by subsection 6, I want to say. The credit agreement applies to any terms whatsoever. So the fact that there's even a question as to what those terms are, whether that was agreed upon at the time of the credit agreement or
The credit agreement, it's a claim on a credit agreement is what's covered by the statute of frauds. It doesn't say anything related to the contract, to a credit agreement. It still has to be a term of the credit agreement, doesn't it?
I mean, and that's kind of the core question at issue. I mean, there's kind of an ambiguity as to what exactly were those terms were at the very beginning. There's some indication by my opposing counsel that there was just part of this business understanding where, you know, we would undertake that as part of the promise to secure financing for this credit agreement. So I think the point is the fact that it's just very ambiguous as to what those terms are indicates that it should be barred under this broad definition of what a contract is.
Contract is, I mean, your broad definition of contract, does that encompass everything that is in contract law in the separate section? Because it seems like this broad definition of contract can help us understand what a credit agreement is under 5C, because credit agreement means any contract made, so forth. But then we have the separate concept of in contract law, and I don't know that those are the same.
I understand your concern, Your Honor. I do agree with my co-counsel that because contract is defined, that kind of justifies what in contract means throughout the entirety of the statute. And I recognize your concerns about, you know, how broad this definition of contract is, how it's outside the normal scope of what we'd understand contract to be. But the legislature can define those terms for, it seems you have a question, Justice Ma'am, sorry.
Any concerns about how they define contract? It's just that contract law is something, you know, I mean, you can define red very broadly, but red car is something else, right?
That I have is that a tort, Your Honor, can I finish my thought quickly here? I would point to a tort in the Iowa Municipal Tort Claims Act that expands kind of the definition of tort very broadly. It's a new, I think our case law refers to it as a new species of cause of action almost. Point being, if the legislature wants to fix this broad term of contract, it should do so.
Legislature make a policy choice that credit agreements have to be in writing to convey any rights. And what would be the effect on this statute if we reversed and said you can have an oral credit agreement and sue in tort?
I think you're reading the question there. It would be catastrophic for the banking industry. It would be catastrophic for the statute in itself, particularly with how we would look at subsection 7, which bars any principle of common law or equity, which I think I agree with Justice McDonald, that includes a tort, for example. For those following reasons, we would ask that you affirm the Court of Appeals decision. Thank you, Your Honors.
Back to Mr. Riley.
All right. Let me first go back to Justice McDonald's question with respect to the evidence. And in our brief at pages 34 and 35, with appendix citations to 1484 through 85 and 1499, Mr. Shalla testified as to the information that he gave Mr. Gert when they met. Now, I'm not talking necessarily about the summary judgment record, but keep in mind, number one, the summary judgment decision was based solely on the fact that Judge Schilling felt constrained to follow the Geiger decision. And secondly, and this,
1 second. What do you mean you're not talking solely about the summary judgment record?
point is, the summary judgment was initially denied. All right, Judge Schilling initially denied the summary judgment. He felt that, well, he granted the acting in concert part and dismissed Mrs. Shalla for parts of it because she was not party to the option agreement, but he denied summary judgment initially. Then a 1904 motion was filed, and then based on that, he granted it solely because he felt constrained to follow the Geiger case as a district court judge. And so that's why, with respect to the summary judgment record, he felt there was sufficient evidence on these claims.
Not the summary judge.
Trial court record, because
The issue before us is not whether something happened at trial that would cast doubt on the prior ruling. We're reviewing a summary judgment ruling and trying to decide whether at the time of that ruling, there was an issue of fact on those papers. And I think what you're saying is no, but there's something that happened at trial.
I'm saying two things, or I want to say two things, and I said one of them, but I do want to get to the second one before I run out of time. Is number one, with respect to the ruling, Judge Schilling said there were genuine issues of material fact, and then he changed the decision solely because he felt constrained to follow it. So, but
Simple question. We're reviewing a summary judgment ruling. The pages in your brief and the appendix, or the record pages that you cite, are those in the summary judgment record or they're the trial testimony? Okay.
But what's clear is that the summary judgment was focused not on the underlying factual basis that Judge Schilling was comfortable with, but rather feeling that he had to follow the Geiger decision. And that, again, segues into the other issue, which is, my client was constrained in resisting the summary judgment motion because of the fact that an agreement was made, it was clearly documented in court filings, and of course, Rule 1506 provides that parties can make agreements on discovery. They removed in the amendments, and we discussed this in our brief, the requirement that there had to be a stipulation, but the court record shows the parties agreed that everything would be set. And this came from People's Bank. They're the ones that wanted it. And so we then, after Gert's deposition was taken, and through no fault of our own, other than Mr. Gert's lack of credibility with the federal court and the delays from COVID, it took a long time before we could depose him. And then suddenly the motion for summary judgments are renewed, and the court rejected our desire to enforce the agreement that People's proposed, and we agreed to, that everything would be reset. I mean, we're sitting here taking
Clarifying question for you. The summary judgment argument relates only to the claims against Peoples and Gert. Just people. Sorry. Not County Bank, not Gert. It's just Peoples. And then what was the compensation that Gert was promised for negotiating the option?
Well, there was no agreement to provide him any compensation. Rather, this is something he was willing to do because it would also result in, or ostensibly looking at it at the time, he was doing that, volunteering to do something additional, or promising to do something additional, because it would assist his business. But I think more fundamentally, what we now know is he was looking at every opportunity he could to get his hands on more money because of the evidence of his constant stealing from bank clients. So I don't have any more time. If there are any further questions, I'd be happy to address them.
That's it from the bench. Thank you. The case of County Bank versus Shalla is hereby submitted, and we'll have a brief pause before we hear the next case, which is Dostart versus Columbia Insurance Company.